The Fifth Circuit Court of Appeals just came out and issued a new ruling saying that United Airlines, their mandates requiring their employees to go and get the jab or else face consequences is coercive. Shocking, I know. Even though many of us have been saying this for some time, how can something like that not be coercive? It's taken a lot of time for the legal system and for many of the government entities to come to the same conclusion. Today, we're going to go through the opinion. It looks like this. You can see a number of different plaintiffs here on top. These are the different United Airlines employees. These are not the actual employees, right? This is not David Sombrano. To my knowledge, I just went and got a United Airlines employee's file photo, and they are suing, the plaintiffs are suing United Airlines. This is the defendant, the company. They're very upset about the mandates, as are many people throughout the world. We can see here the circuit judges who are listening to this case are Smith, Elrod, and Oldham, and this is an appeal from the district court out of the Northern District of Texas. And so remember how this works. We're in federal court. We're going to go to a lower level district court here, Northern District of Texas. Texas here ruled against the plaintiffs, said, hey, United Airlines employees, I'm sorry you're upset about these mandates, but it's their company. They can do whatever they want to do. And so they appealed it. And what we're going to see here is the Fifth Circuit is finding in favor of the plaintiffs, saying that no, this is in fact coercive, United Airlines. You can't do this the way that you were doing it. So let's break this down. The Fifth Circuit, of course, is covering Texas, Mississippi, and Louisiana. You can see these are the different lower level district courts, and this is taking place out of the John Minor Wisdom U.S. Court of Appeals building. Let's take a look at the opinion. Now, this is not being written by any particular judge. You can see this is a per curiam opinion, which means it's just the opinion of the court, not identifying any particular judge who is going to be sort of signing off on this thing. But we get some background here. And so it's a really long filing. I think it's 80 pages. And so I just sort of took out the facts and then the relevant parts of the ruling. But let's get some background here. It says plaintiffs are United Airlines employees. They're the people bringing the lawsuit. And when they were working there, United gave them a choice. Get the vax or be placed on unpaid leave indefinitely, okay, until you go get the jab. Always felt to me like that was just obviously coercive, but here now we are. The question we address is narrow, the court says. If United's policy is not stopped, are the plaintiffs going to suffer irreparable harm, right? If this policy continues, are the plaintiffs going to be facing harm that there can be no repair for? For the two plaintiffs who receive religious exemptions and remain on unpaid leave, we are told that they are. We therefore reverse the decision of the district court and remand for consideration of other factors. Critically, they say, we do not decide whether United or any other entity may impose a mandate, nor do we decide whether plaintiffs are ultimately entitled to a preliminary injunction. The district court denied those things, and we reverse on that one narrow ground and remand for further consideration, okay? So this is very narrow. This ruling is not going to be something that anybody's going to be able to sort of take to their employer and say, see, look what they did. They're saying very, very narrow, and there's another footnote in here saying we're going to sort of narrow this precedential value as this case is ruled only, the opinion is only relevant for these particular facts, is what this court is saying. But it is still good news nonetheless, right? This is an idea or an indication that the Court of Appeals are hinting towards resolving these in a certain manner. And this is what's called persuasive precedent, right? This is something that other courts of appeals can look to and say, oh, well, look how they're doing it. They found that under those sets of facts, it was in fact coercive. And so now that we're facing a different set of facts, well, maybe we might find that ours is also coercive as well. And so let's go back to the opinion. You can see here more facts. Court details for us. They say in August 2021, United announced that each of its U.S. employees would be required to get the vax. The announcement came with a deadline, either 5 weeks after it was formally approved or 5 weeks after September 20th, whichever was sooner. FDA approved the vax on August 21st, 2021, which set the deadline for September 27th. Employees who were not vaxxed by that deadline were fired. United does not require any passenger on its planes to be vaxxed, nor does it require its employees in other countries to be vaxxed, even those even though those employees work with and come into contact with US-based crews. So it's only US employees and not even the passengers. And neither does it require pilots from other airlines who ride in the cockpit to be vaxxed. So if you work for another airline and you just happen to be flying for United on that day, you can be exempt from this stuff. Carries on. Says United, the company, purported to provide exemptions for those who could not get vaxxed for either religious or medical reasons, saying, okay, look, if you've got a medical exemption or religious exemption, we will technically give you one. They said, that is, within 10 days after the approved COVID vax, a United employee could apply for an exemption from the mandate for one of those reasons. But at a town hall meeting, United CEO warned that not many exemptions would be granted and remarked that any employee who, quote, all of a sudden decided, quote, I'm really religious, would, quote, be putting her job on the line by requesting an accommodation. Nice guy. Once an employee requested a religious exemption, United would ask employees about their past vaccinations. Oh, you have a religious objection to the COVID vax? Well, what about your other vaccines? Did you get those? Let's see. Also asked about the use of stem cells and, quote, why receiving such vax were not a violation of the employee's sincerely held religious belief on those prior occasions, saying, oh, well, you did these other things. Why now all of a sudden are you objecting to this COVID vax? United also asked why the employee's religious beliefs prevented them from receiving it, but not taking other types of medicine. Okay, so making people sort of, dissect their internal beliefs. Some employees were asked to provide a letter from a pastor or a third party attesting that the employee actually held the religious beliefs. We don't believe you. Can you go to your church and talk to your pastor about it? Like, do you have an attendance schedule? Do you have a sign-in sheet when you go to your church and, every time you take the Eucharist, are they marking it down? Oh, Robbie's back again. Here he is. Oh, okay. So you can see that seems like it might be, in fact, a little bit coercive. And the court is noting that, saying this is kind of a bizarre thing. United's bizarre inquisition into the sincerity of its employees' beliefs is somewhat at odds with our usual approach of taking parties at their word regarding their own religious convictions. The idea that we don't really have religious tests in this country, like, why don't you go make a sacrifice of a goat, and then I'll make sure. Okay, that sounds like it's a good religion. All right. And so we'll finally believe you because you went and did something to verify your faith? Lunatics. The opinion goes on, more details. It says, after United would determine which employees were sufficiently religious according to their standards. Oh, you pass our test. It provided those employees with, quote, an accommodation. The employee could keep her job, but could not go to work, would not be paid, and would not receive any company benefits. So that's a nice job that you don't work or get paid for. Real nice. To go back to work, the exempt employee had to get the vax. And if the employee would not, she would instead wait it out and start work again after the pandemic, quote, meaningfully recedes, which United said at the time would be another, 72 months or so. 72 months. Like half a decade, give or take a decade, 5, 6, 7 years, no big deal. United campaigns was not limited to forcing employees to choose between the vax and indefinite unpaid leave. For example, in August, United began sending postcards to unvaxxed employees stating that United had not received evidence of their vax and they needed to get it in order to avoid, quote, being separated from United. Sending postcards. Reminder, did you get your shots yet, employees? Plaintiffs credibly contend that United sent postcards rather than letters in order to broadcast employees' unvaccinated status to family members and enlist those family members in coaxing employees to receive the vaccine, right? Taking advantage of their private knowledge of a person's medical condition, saying, oh, we know that person hasn't gotten the jab, and so we're just going to send them a postcard that is communicating their status to everybody at that address and the postman and everybody who is handling that line and saying, oh, Robert here is getting one of these letters. Oh, I wonder why that might be. Right? Everybody in the line taking advantage of a person's private medical records. Garbage company. Plaintiffs are several United employees who requested these accommodations. Plaintiffs filed EEOC, so Equal Employment Opportunity Commission, charges in September. But because of United policies, it's going to go into effect before they got the right to sue. Plaintiffs sued and they moved for a preliminary injunction. Okay, so technical stuff going on here. Plaintiffs say United has put its religious and disabled workers in an impossible position. Either take the jab at the expense of your beliefs or face a lengthy period of unpaid leave. You are making us have to decide between two impossible decisions. One, violate our religious beliefs, or two, be paid, unpaid, indefinitely. Could be up to 72 months. Very long time. 72 months, yes, very long time. After plaintiffs filed suit, United changed its policy to now allow certain employees with non-customer facing operational roles, for example, like mechanics, the accommodation of working pursuant to a masking and testing protocol. Okay, so now you can come back, but because you're a dirty person, we're going to make you follow all of these additional restrictions. United also permitted some customer service reps to work in remote positions rather than taking leave. This allowed three of the plaintiffs, Kimberly Hamilton, David Castillo, and Deborah Jones, to continue to work and be paid without receiving the jab. But for customer-facing employees, including pilots, flight attendants, and most customer service agents, indefinite unpaid leave remains the only accommodation that United will provide. David Sombrano and another plaintiff, a pilot and a flight attendant, fall into this category and are only eligible for the unpaid leave. No accommodations for them. And so the question that we have to ask is that coercive? Are these policies coercive? Is it damaging to those individuals? The court tells us the question presented to us in this appeal is whether the lower level district court erred, whether they screwed up by denying them their injunction, saying that they have not demonstrated irreparable injury. Okay, the lower level Texas court said, sorry, employees, you lose because you haven't shown us that what United is doing is actually causing you irreparable injury. If the policy continued, you can't show us that you're actually going to be harmed. The court says that's nonsense. We hold the district court did screw up. As to the plaintiffs, they are on unpaid leave. Plaintiffs are being subjected to ongoing coercion based on their religious beliefs. That coercion is harmful and it cannot be remedied after the fact. If we let this go on, the harm is going to continue to compound and we can't go fix it. There are some types of harms that if somebody's being harmed, yeah, you can go back and fix it. How do you, well, more money or, give somebody a new present, nice flowers. Oh, yeah, that solves everything for thank you. But in some situations, not going to work. And so the court gives us some more analysis. They say here, in this case, plaintiffs alleged exactly the type of exogenous and irreparable harm that we've talked about in other cases. Specifically and crucially, plaintiffs here are not seeking an injunction merely to prevent an adverse employment action or any harm that would come from that. Okay, they're not like trying to stop it from being fired or something like that. Here it says their allegation of irreparable harm is based on the coercion. It's antecedent to and independent from and exogenous to any adverse employment action. Specifically, the employees say that United wants to coerce them into getting a vaccine that violates their sincerely held religious belief and thus avoid any adverse employment action, saying that this is more about the religious belief and the coercion into violating the religious belief than it is about avoiding being terminated. Properly understood, let's break this down. The court says there are two distinct harms. We can take this and sort of bifurcate it into two. One of which is reparable. Okay, one of these harms, yeah, you can just pay some money and it'll be fine. Okay, this is United's decision to place them on indefinite unpaid leave. That harm and any harm that flows from that, you can remedy that. You can just pay them, back pay, you can reinstate them, you can do other things, right? Settle with them, give them a compromise, and deal with that. But the second form of the harm flows from United's decision to coercion, the plaintiffs into violating their religious convictions. That harm, and that harm alone, is irreparable. and it supports a preliminary injunction. United Airlines is saying, we want to continue forward with our mandates on our policies, and there really is no harm that is irreparable. Okay, they're going to be placed on indefinite leave, and so let us sort through some of these lower level litigation issues before granting this injunction, because there really is no irreparable harm. But the court kind of really zoomed in on this thing, pinched on in there and said, no, there are two types of harm. One of those is in fact reparable. Yeah, you can just give them back pay, you can reinstate them, and they'll be okay, right? If you brought them back and you said, sorry about this, we're going to give you back pay for all of that and pay you a little bit more for the harm, whatever, you can kind of repair some of that. But the other, asking somebody to violate their religious beliefs and causing them to put something into their body that they don't want to for whatever justifications they want, demanding that they sort of comply with religious tests and identifying them and broadcasting them to the community at large. All of these things are urging people to sort of violate some of the most sacred beliefs that exist, if not the most sacred beliefs that exist in most people's lives. Feels coercive, always felt coercive. And finally, the Fifth Circuit agrees. Now, we'll see where this continues to go. We're going to very likely see a circuit split on these issues continue to develop until the Supreme Court comes in and weighs in on this. We'll continue to follow along. I hope you join us. We have a live show that we do every weekday. I would love it if you hit that subscribe button and joined us on the next one. I look forward to seeing you there.